You paid your mortgage. You paid your taxes. You even paid your HOA dues, your Homeowners Association fees, every single month, on time. But because your grass was 2 inches too long, they took your house. And the Supreme Court never had to get involved. Neither did a judge. Neither did a jury. A private board, in a folding chair meeting, signed a piece of paper, and your house became theirs. This isn't a hypothetical. This happened to a U.S. Army captain while he was commanding 100 soldiers in Iraq. In 2009, Captain Michael Clower deploys to Iraq. Back home in Texas, his wife battles depression. The mail piles up. Certified letters from the HOA sit unopened on the kitchen counter. Letters she can't bring herself to face. Michael owns his house outright. $300,000. No mortgage. Paid in full. The safest asset a soldier can have while he's overseas. The HOA claims he owes $800. While Michael commands troops in a war zone, the Heritage Lakes Homeowners Association files a non-judicial foreclosure. No courtroom, no hearing where he can defend himself, just a trustee, a notice, and an auction date. They sell his house. Final price? $3,500. An $800 debt just erased $300,000 in equity, while the owner was risking his life for the country that let this happen. How is that legal? You're about to watch the machine that did it. Here's where it starts, for you and for Michael both. You buy a house in an HOA neighborhood. You sign a document called the CC&Rs, covenants, conditions, and restrictions. That contract hands the board the power to fine you for grass length, paint color, even where you park. You treat these fines like parking tickets. Small, annoying, ignorable. A parking ticket can't take your house. An HOA fine can. Say you get a $50 fine. You disagree with it, so you skip that fine and pay your normal $200 monthly dues instead. Here's the part almost nobody knows. Your $200 doesn't touch your dues first. The system swallows it into the fine. Then late fees. Then administrative charges. Your dues account now reads unpaid, even though you just paid $200. This is called the payment allocation waterfall. It's the single most dangerous line of fine print most homeowners never read. And it's the mechanism that turned Michael's $800 into a foreclosure notice while he was 7,000 miles away. Once the system marks you in default, your interest starts stacking. 18% a year in some cases. You're now paying 18% on a $50 fine. That's not a late fee. That's a loan shark rate. And your HOA doesn't need a license to charge it to you. Then your account goes to a law firm. Every letter they send you, every phone call, every court filing, it all gets billed straight to you. In documented cases, legal fees eat up 75 to 90% of the total debt. Your $50 grass fine becomes a $5,000 lien in months. And that lien attaches to your title exactly like a tax lien. Here's the part that should terrify anyone with a mortgage. Once that lien is recorded, the HOA doesn't need your lender's permission to foreclose. Your bank can be completely out of the loop. In states like California and Texas, the association skips the courtroom entirely. A trustee records a notice, sets a date, and auctions your home on the courthouse steps. No judge, no trial, just a certified letter you might miss, the way Michael's wife missed hers. But here's what Michael didn't know, and what your HOA probably isn't telling you either. That $800 debt wasn't even the real reason they could move this fast. The real reason is a single line buried in property law that treats your HOA almost like a government agency. It's called super priority status. Under the Uniform Common Interest Ownership Act, adopted in more than 20 states, a portion of your HOA debt jumps ahead of your first mortgage in line. Not behind it, ahead of it. That means the HOA can foreclose wipe out junior debts, and in some cases, force your bank to pay the association just to protect its own loan. Your 30-year mortgage doesn't shield you. Your bank might be just as blindsided as you are. You might be thinking, I have a homestead exemption. Texas and Florida have some of the strongest constitutional protections for primary residences in the country. A normal creditor can't touch your home. Courts ruled otherwise for CC&Rs. Why? Because you signed that contract before you ever moved in, before your homestead protection even started. Courts call CC&Rs pre-existing contractual covenants that run with the land. You agreed to the fine print the day you bought the house. The Constitution protects you starting the day you live there. The contract wins because it came first. And then there's credit bidding. At the auction, the HOA doesn't need cash to win. It bids using the debt judgment itself. Outside investors don't want a house with title clouds and a pending mortgage attached, so most walk away. The HOA wins by default for the price of the debt. A $300,000 home, no mortgage, sold for $3,500. The HOA bought it for roughly the price of a used Honda Civic. That isn't theory. That's Texas property law. That's Michael Clower's house. This machine was already running on people long before Michael. 8 years earlier, in 2001, an 82-year-old widow named Winona Blevins lost her paid-off $150,000 home over $814. Legal fees pushed it to $4,000. The state only acted after an eviction notice was taped to her door. Texas passed a law named after her, and it still wasn't enough to stop what happened to Michael 8 years later. In Denver, one single HOA, Green Valley Ranch, filed 50 foreclosure actions in a single year, nearly half the city's total, all triggered by unmowed grass and trash cans left at the curb. One resident watched $5,000 in appearance fines balloon past $20,000. He lost his home, too. In Florida, homeowner Shonya Cruz Munoz repainted her house 3 times trying to satisfy her HOA's color standards. She still ended up in a payment plan just to stop a sheriff's sale after $9,400 in attorney fees alone. Same machine, different names every single time. Nearly 1/3 of all U.S. housing now sits under HOA governance. New developments build mandatory HOAs to shift infrastructure costs, private roads, storm drains, streetlights, off municipal budgets and onto you. Often, you can't buy the house without joining. And the moment you join, the CC&Rs hand the board legal authority to turn a grass complaint into a secure debt against your home. But homeowners started fighting back, and in some states, they actually won. The fight back is real. Colorado passed House Bill 22-1137 after Michael's case and others like it. HOAs there can no longer foreclose solely over fines, and default interest is capped at 8%. Texas passed the Winona Blevins Act, forcing longer notice periods. Florida's House Bill 1203 caps fines at $100 a day, and this is the important part, rewrites the payment order by law. Interest first, late fees second, collection costs third, principal last. That one change breaks the waterfall. But these laws are state-specific, recent, incomplete. If you don't live in one of these states, the old machine still runs exactly the way it ran on Michael. And Michael, he fought back, challenging the sale under a federal law that's supposed to protect deployed soldiers from exactly this. After years in court, the sale was overturned. But the fight took years, dragged through federal court while his family lived with the damage already done. Winning doesn't give you those years back. So, if a pink envelope from your HOA shows up this week, here's your actual playbook. Step 1. Grab your phone right now and photograph your lawn, your paint, whatever they're flagging, before you fix anything. That photo is your evidence the violation existed and how bad it actually was. Step 2. Submit a written dispute and demand a formal hearing before the board. In many states, that request pauses the enforcement clock immediately. Step 3. Keep paying your regular dues, but write "paid under protest, regular assessment only" on the memo line and mail it with a certified cover letter. That's your paper trail if the manager tries to run your payment through the waterfall. Step 4. Demand an itemized ledger. States like Florida and Colorado penalize associations that don't hand over records within 10 business days. And if foreclosure gets threatened, check whether your state requires mediation first. Florida and California mandate it before a foreclosure lawsuit can proceed. A formal mediation demand stops the law firm's momentum cold and moves the fight out of their hands. In the United States, contract law and property law intersect in ways most people never expect. A $50 administrative penalty isn't a parking ticket. It's a doorway into a debt machine that can consume your equity, bypass your mortgage, and end with an auctioneer standing on your front lawn. The reforms are real, but until they're universal, the only real defense is understanding the machine before it starts running on you. And before you think this only happens with houses, next week we're looking at the 19th century maritime law that still decides who owns your lost airline luggage and why the airline's liability might legally end the moment your bag hits the conveyor belt, even if you never see it again. The airline doesn't want you to know this one. You'll want to see it.